Good morning, Ms. Loxton. Is everybody in?
Yes, Justice, all counsel are online. May I proceed?
Yes, please.
Thank you, Justice. Good morning, I'm the Registrar Clerk for this hearing. Justice Madlanga and Justices of the Constitutional Court, all counsel are online. I call the matter of Municipal Employees Pension Fund and another, and Dineo, Innolentia, Mongwaketse for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
May it please the court, I appear for the applicants in this matter.
Thank you, Mr. McNally.
Justice Madlanga, Justices of the Constitutional Court. My name is Sandile Khumalo. I appear together with Mr. Magan and Ms. Mbata on behalf of the Amicus.
Thank you, Mr. Khumalo. Mr. McNally.
Thank you, Justice Madlanga. Justices, as you know, the applicant seeks leave to appeal against the judgment and order of the majority in the Supreme Court of Appeal, which upheld the determination of the pension funds adjudicator in relation to a complaint that was brought by the respondent, a Ms. Mongwaketse. The adjudicator found that Ms. Mongwaketse was not a member of the fund, the applicant fund, and ordered it to repay her all the amounts she had paid to it, plus interest. The applicant raises a primary and a secondary argument in support of its case. Its primary argument relates to the adjudicator's jurisdiction to consider the matter placed before her by Ms. Mongwaketse. In relation to that jurisdictional argument, I intend, with your leave, to make two alternative submissions. My first submission is that the complaint submitted by Ms. Mongwaketse was not a complaint as defined in the Pension Funds Act, and therefore that the adjudicator had no jurisdiction to consider it at all. In that regard, the argument turns on the meaning and ambit to be given to the concept of a complaint and a complainant, both of which are defined terms in the Pension Funds Act. It will firstly be contended that Ms. Mongwaketse was not a complainant as defined, and that's because she approached the adjudicator on the basis that she was not a member of the fund. Secondly, it will be contended that her complaint, emanating as it did from a non-member who was not governed by the rules of the fund, did not relate to any of the three subjects referred to in the preamble of the definition of complaint. And in that regard, it will be argued that the determination of a complex common law claim, such as one for unjustified enrichment, is clearly beyond the jurisdiction of the adjudicator. Those arguments then are based on the premise that Ms. Mongwaketse approached the adjudicator on the basis that she was not a member of the fund. But in the alternative, if it's found that Ms. Mongwaketse approached the adjudicator claiming to be a member, which is an arguable proposition and one which was entertained by Justice Wiener in the Supreme Court, then it would follow, if she did that, that she was indeed a complainant and she would clear that hurdle. However, in that event, I will argue that once the adjudicator determined that Ms. Mongwaketse was not entitled to be a member, then that exhausted the extent of her jurisdiction. The further claim by Ms. Mongwaketse, which was a claim for return of the payments made by her, fell outside the definition of a complaint, again because it didn't relate to any of the three subjects in the preamble. And accordingly, it will be submitted that the adjudicator again lacked jurisdiction to consider that claim. Justices, we will submit that that should be the end of the matter, because the adjudicator lacked the necessary jurisdiction to make her determination. However, both the High Court and the majority in the Supreme Court of Appeal, and now also CALS, the Center for Applied Legal Studies, who intervenes as an amicus, advanced the view that our interpretation of complaint and complainant is too technical and restrictive and unduly limits the ambit of the adjudicator's jurisdiction. If this court were to adopt that view and determines that the adjudicator indeed had jurisdiction to make her determination, we nonetheless contend that the determination falls to be set aside. And in regard to that secondary argument, we again put up two main submissions. First, we submit that the procedure which the adjudicator adopted was flawed in various respects, as a result of which her determination falls to be reviewed and set aside. And secondly, we contend that her determination was in any event wrong on the merits and should be set aside on appeal. On the merits, we again make two arguments in the alternative. We first contend that in fact Ms. Mongwaketse was a member of the fund, or fell to be treated as a member of the fund. But secondly, if we're wrong on that, then we say that the requirements for an enrichment claim were not met. That then is a summary of the structure of our argument. Can I turn then to develop the primary argument relating to the adjudicator's jurisdiction? Both the High Court and the majority in the Supreme Court of Appeal held that the adjudicator had the necessary jurisdiction to deal with Ms. Mongwaketse's complaint. They got there by slightly different routes, but both involved an expansive interpretation of the definitions of complaint and complainant. Before turning to those interpretations, which I'll do in a moment, it's necessary to examine Ms. Mongwaketse's complaint to see and to interpret its nature. Justice Wallace makes the point, which we accept, that complaints are not pleadings and are prepared by lay persons in lay language. And he says that one must look not to the form, but to the substance of the complaint, and we accept that. Both the majority in the Supreme Court and Justice Ponnen, in his minority judgment, read the substance of the complaint as being that Ms. Mongwaketse did not qualify to be a member of the fund, but had been accepted as a member and made contributions on that basis. And what she wanted was her money back with some return. On that basis, as was expressly held by Justice Ponnen, Ms. Mongwaketse was not and did not claim to be a member. In fact, on the contrary, she claimed not to be a member. That analysis of her complaint appears to be justified on a fair reading of the letter of her complaint, and we refer in that regard particularly to volume 6 of the record, page 593, at the second paragraph, where she herself says in her letter of complaint, according to the rules of the pension fund, I am excluded as member, which means, to begin with, I shouldn't have been a member. And that's also how she saw her complaint in her affidavit filed in the High Court. And I won't take the court to that reference, but it's at volume 1, page 111 to 112, at paragraphs 5.27 to 5.30. Unfortunately, Justices, there's some ambiguity introduced into the complaint, because while simultaneously asserting that she was not a member, Ms. Mongwaketse somewhat inconsistently claimed relief that appeared to be relief in terms of the rules of the fund, which she could only be entitled to as a member. And you will find that in her complaint at volume 6, page 593, under the heading Recommendations, where she claims the payment of all contributions made by her times 1.5, which is the formulation of the payment on retirement as set out in Rule 37(1)(b) of the rules. And it was that led Justice Wiener, in her dissenting judgment, to accept that Ms. Mongwaketse in fact claimed to be a member of the fund. However, despite that ambiguity, we submit that on either basis, whether Ms. Mongwaketse was claiming not to be a member or whether she was claiming to be a member, nonetheless, we say that the adjudicator exceeded the limits of her jurisdiction.
Mr.
And that brings us...
The 10 minutes is up, but please continue.
Thank you, Justice Madlanga.
Mr. McNally, before you proceed, you said that your starting point would be on the definition of complaint and complainant. I'm interested to hear on that. If you look at the definition of complainant in the Act, why is Ms. Mongwaketse not covered by D in the definition of complainant? Any
yes, Justice.
Interest in a complaint?
Yes, Justice Cheeky, that is exactly, of course, what both the High Court in the person of the late Mr. Justice van der Linde and also the majority in the Supreme Court found. They gave...
Why are they wrong?
They're wrong for this reason, Justice Cheeky. If you give subsection D the wide interpretation that was given to it by the Supreme Court, then essentially you do away completely with the subcategories A to C, because those categories would in any event fall under D. All those people would be persons with an interest in a complaint.
But is that not what the definition says?
I'll tell you why we say not, Justice Cheeky. D says any person who has an interest in a complaint. But one must recall that a complaint itself is defined as the complaint of a complainant. So what we say D means, and it's the only way to give it meaning while preserving the meaning of A to C, is it's any other person other than one described in A to C who has an interest in a complaint of a complainant who is described in A to C. So that far from being a circular argument, that in fact ties up the definitions of a complainant, because what it does is it says that a complainant essentially is a member or someone who claims to be a member, or a beneficiary or someone who claims to be a beneficiary, or an employer or someone who claims to be an employer, and then a group of persons that falls under that definition, or the board of a fund. Now that's essentially...
And then it says or, and then it says or any person who has an interest in a complaint.
Yes, Justice, but it's important that where it says has an interest in a complaint, that means has an interest in a complaint of a complainant. And to give that meaning, it must be referring to a complainant as set out in A to C. So it's not, if it's simply a catch-all, if it's a catch-all and catches everyone, then there was no point in the careful formulation of the definitions in A to C, because all those people would be people who have an interest in a complaint. So either A to C refers to members, beneficiaries, and employees who do not have an interest in a complaint, which would frankly be absurd, or it means that where D refers to a person who has an interest in a complaint, it means another person who has an interest in a complaint which has already been laid by a complainant in A to C.
I hear you. If we go to what a complaint is.
Yes.
You're saying that he's also not covered there. Could he be I see?
No, no, we don't say that at all. What we say though, is that the important part of that definition of complaint in relation to subsection or subclause D of the definition of complainant is that a complaint is a complaint of a complainant. Now, it's a very strange wording, and both the High Court and the Supreme Court said, well, it leads to circularity, and you must therefore leave out the reference to of a complainant when you refer to a complaint in subsection D. But we say that that is not the correct approach. It's not correct to leave out some words. It's rather correct to try and incorporate those words and make sense of them. And we do that by our interpretation. So that, and I repeat, and I apologize for repeating it, but if D were to mean what you are suggesting, Justice Cheeky, and indeed what the High Court and the Supreme Court of Appeal held, then there would simply be no purpose in the definitions A to C.
But at least you agree that what she lodged was a complaint.
Well, it's only a complaint, A, if she's a complainant, and B, if it falls within one of the three subject matters that appears in the preamble to the definition of a complaint. So our first submission is that it's not a complaint because she was not a complainant. Now that's a critical point, because she's not a complainant because she doesn't come to the adjudicator as a member or as somebody claiming to be a member. In fact, on the contrary, she comes to the adjudicator as a person claiming not to be a member. And therefore let me
wrap up, Mr. McNally. I'm sorry to keep on interrupting you.
Not at all, Justice.
Yes. If I were to find that she is covered by D, then there is no problem in my thinking that what she lodged was a complaint.
That's correct, Justice.
Okay.
Well, there are 2 points. There are 2 points that need to be answered in that regard, and it's important to distinguish between the two areas of argument. The first is that we say that if she came to the adjudicator claiming not to be a member, then she is not a complainant, and then this is not a complaint because it doesn't fall under the definition of a complaint, which requires to be the complaint of a complainant. And she can't simply be lumped into D because she's not an additional person who is suggesting that she has an interest in a complaint of a person A to C. So it's not a complaint. But there's another reason why it's not a complaint in those circumstances. And that is that her complaint didn't relate to any of the three subject matters in the preamble to the definition of complaint. Those are that it must relate to the administration of a fund, the investment of its funds, or the interpretation and application of its rules. And we say that if she approached the adjudicator as a non-member, seeking repayment on the basis of some form of enrichment claim, then her complaint does not fall within any of those three categories. And the reason we say that
was her complaint not in relation to the interpretation of the rules of the fund?
No, because she approached as a non-member, and therefore there was no need to interpret the rules at all. She said, I am a non-member and I want my money back. You don't need to look at the rules at all for that complaint. She is a non-member, and you don't need to look at the rules to see whether she's entitled to her money back. It's an enrichment claim. So it doesn't relate to the administration of the fund. It doesn't relate to the investment of its funds, and it doesn't relate to the interpretation or application of the rules. So our submission is not so, particularly if she approached the fund as a non-member. Then it was entirely outside the ambit of the fund and its rules. And that's an important aspect to our entire argument, because that's exactly why we say that one shouldn't interpret the jurisdiction widely, because you end up imposing on the adjudicator the obligation to determine complex issues of common law, which are not the type of issues for which she was set up to determine. Obviously, her expertise lies in resolving disputes between members and related parties in relation to the rules of a pension fund. That's exactly where her jurisdiction lies. But where you interpret complaint and complainant in the manner that the High Court and the Supreme Court of Appeal did, then you end up with exactly the difficulties that were recognized by the two minority judgments, which is that you place the adjudicator in the invidious position that she must determine common law claims outside of her area of expertise. Now, I said that there were two answers to your question. And the second answer to your question is that it could be argued that Ms. Mongwaketse approached the adjudicator claiming to be a member. Now, that we say, or we accept, is arguable. We don't agree with it, but we accept that it's arguable, and it was indeed what was found by Justice Wiener in the Supreme Court. You will find in her judgment, and indeed some support was given to it by Justice Wallace, although somewhat as an aside, at volume 4, page 386, paragraph 34. I won't read it there, but essentially he said that one could consider Ms. Mongwaketse to be someone claiming to be a former member of the fund. And certainly Justice Wiener accepted that she was claiming to be a member of the fund. Now, if that's so, then she would, we accept, fall within the definition of a complainant under sub A, because she would be a person claiming to be a member. And if the adjudicator then found that she was indeed a member on any basis, then her subsequent claim would have been a claim which fell within the definition of a complaint, because it would have involved the issue of what was due to her as a member in terms of the rules. But here, the adjudicator determined that she was not a member. And at that point, and this is an important submission for our case, we say that the only issue over which she had jurisdiction was then determined. And we say that because the further claim for repayment of the amounts that she had paid to the fund again, for the reasons already advanced, had nothing to do with the administration of the fund, the investment of its funds, or the interpretation or the application of its rules. Quite the contrary. It was a common law claim for enrichment outside of the framework of the fund entirely. And we therefore submit that in proceeding to determine the enrichment claim, having found that she was a non-member, the adjudicator exceeded her jurisdiction because an enrichment claim doesn't constitute a complaint as defined.
Thank you, Ms. McNally. Thank you, Ms. Justice Madlala.
Thank you,
Mr.
Justice.
McNally, sorry to come in here. Can I just ask on your interpretation of paragraph D of complainant, can you give me a practical example of a person who might become a complainant in that way? In other words, in a case where there is an existing complaint by a person in categories A to C. Sorry.
Yes, sorry, Justice Rogers, I did hear you.
Yes.
I'm just considering the question and taking an instruction. It's difficult to come up with an example off the cuff of someone who might have an interest, but there may indeed be, well, so the starting position is that you have a complainant who brings a complaint. You then have a third party who, for one reason or another, and that's what I'm trying to come up with, and that's really to what your question relates, has an interest in that complaint. I can't for the life of me for the moment think of someone who might fall within that category, but it seems that there must be occasions where a third party may have an interest. Remember, of course, that it needn't be a third party who is entirely unrelated to the pension fund. It may be another complainant who falls under A, B, or C, but who has an interest in an existing complaint. That would still be someone who fell under D. So it would be either another complainant or a third party. I'm trying to think of whether a creditor, I'm just battling to think of an example, but I will give that some thought, Justice Rogers, and come back to you if I have an example of someone who would readily fall into that category, other than, as I say, another complainant who is simply participating in an existing complaint.
Yes, I don't, on the face of it, another member with his or her own complaint wouldn't need to rely on D. They would just put up their own complaint, relying as a complainant under A, and if the complaints covered similar grounds, they might be dealt with together, or you could say the adjudicator should consider them together, or they would become a group of members under paragraph B.
Yes, they may do it that way, or they may join in the complaint as is provided for indeed under 30 sub J, I think it is, which provides for a joinder of parties.
Would you accept that the significance of being a complainant is that one is seeking some adjudication in one's favor? Paragraph section 10G allows for other parties who have an interest in a complaint to be joined, not at that stage, I don't think, as complainants, or not necessarily as complainants. Yes. So persons who have an interest in the outcome of a complaint, but are not themselves complaining and seeking an adjudication in their favor, can be admitted under 30G. So it appears that the examples that you will perhaps think about and come back on in reply would be a person who is seeking some adjudication in their favor by virtue of their capacity under paragraph D. Now, on Ms. Mongwaketse's argument, which if D covers, for example, the case of a non-member who's erroneously made payments to the fund, that argument doesn't present difficulty on her approach. But I think the practical existence or absence of realistic examples may be an important consideration in interpretation. Would you accept that?
Yes, Justice Rogers, absolutely. I do accept that. If there was no one who could fall into that category, then it would suggest that that category had no meaning, and that would be a problem from an interpretive point of view. I accept that. But
Yes.
we do say that, and indeed it may be the proposition you suggest may be an important one, and that is that if Ms. Mongwaketse approaches the adjudicator on her own, but as a non-member, then we would say she's not a complainant. But if she approached the adjudicator on the basis of an existing complaint against that fund in similar circumstances, then she could fall under D, which she wouldn't fall under if she was on her own, because she wouldn't be joining in a complaint of a complainant.
Mr. McNally, could she have maybe, we know that she contributed funds to her monies to the fund, and the fund accepted those monies. So can one then say that the complaint related to the fact that she was accepted by the fund to be a member?
The difficulty with that argument, and we raised this difficulty later, is the difficulty that was raised by Justice Wallace. And that is that, on the one hand, if it is held that she was not entitled to be a member, then her funds did not form part of the pool of funds of the fund as a matter of law. And therefore, the claim for those funds doesn't fall into the administration of funds category. Now, of course, we would argue that even though that may be correct, that's not an answer to the enrichment claim, where we make a similar argument, namely that the fund was not enriched and she was not impoverished because she received benefits. Now, those look on the face of it to be contradictory arguments, but we say they're not, because the one is an argument of law, which is whether, as a matter of law, those funds could form part of the pool of funds of the capital F fund, or as against an argument of fact as to whether the fund was in fact enriched or she was in fact impoverished. So we would submit that the funds that she paid as a non-member were not contributions and were not properly to be used in the fund, as His Lordship, Mr. Justice Wallace, points out in his judgment.
So where would she claim then, according to your argument? Should she then go to the municipality and say, you paid my 22%, I'm talking about the 22% that was paid to the fund on the basis that it's a contribution by the municipality. We know that she in fact is the one who paid it.
Yes, in our submission, she has a claim against the municipality in relation to her contract with it. And she also, of course, has an enrichment claim. We're not suggesting she may not have an enrichment claim. All we're suggesting is that that enrichment claim does not fall within the jurisdiction of the administrator. She may have an enrichment claim, but it would be a claim which she raised in a court, not before the administrator, because it's beyond the jurisdiction of the administrator.
And it would not be your concern if the municipality says that claim is prescribed. That is, it matters not insofar as the fund is concerned.
We do contend that most of her claim has prescribed. That's her claim. If it's a claim in unjustified enrichment, most of it will have prescribed, because the claim arises as soon as the amount is paid. and therefore the claim began in 2012 and proceeded until 2014, which was 3 years before she lodged her complaint.
Is that a correct contention? She says she became aware of this problem in 2014.
Yes, we say that by the exercise of reasonable care, she could have become aware of it from the outset, because the rules of the fund, which is the basis for her claim that she's not a member, are publicly available, and she could have and should in fact have sought them out, and she would then have realized that she on her version didn't qualify as a member, and therefore her claim would have arisen at that stage.
Thank you.
Just linked to that question, Mr. McNally, is it the applicant's position that what was contributed was not solely from her, that the 22% came from the municipality?
Yes, Justice Curiae, again, there are two answers to that. From her perspective, it appears that the amounts came out of her salary or were paid out of her salary. But from the fund's perspective, that simply cannot happen. And the fund requires, and she accepted, that her 7.5% was paid by her and the 22% was paid by the municipality. That would mean that in regard to the 22%, her claim should properly be against her employer, the municipality, for a breach of that arrangement with her. So that's the answer to that question, Justice Curiae.
But the municipality confirms that that 22% came from her in terms of the remuneration arrangement that they've had with her.
Well, it was all paid by the municipality. It was all paid over by the municipality.
As a conduit,
it was an arrangement as between the municipality and her that the 22% would come out of her salary, but that's not an arrangement which in fact can subsist vis-a-vis the fund. It only accepts contributions which are paid 7.5% by the member and 22% by the employer.
Is there any legislative prescription as to how the funds or the contributions should be employed by the fund? To say 7.5% will only go for this, and the 22% from the employer will be apportioned for this purpose?
The rules don't specify how the funds should be used, but the rules do specify that the member will pay 7.5% of its of his or her emoluments, and the municipality 22%.
But then why should it matter if the rules don't specify, if both parties say that the money, all the contributions came solely from her?
Precisely for this reason, because the rules then determine how the payout should be made. And the rules determine that the payout on retirement is the 7.5% contribution times 1.5, which is exactly how she was paid out here. Now, if she was paying 7.5% of her salary, that would have been an entirely reasonable and proper payout. But where she's paying the full 29.5%, then a payout on retirement of 7.5% times 1.5 is a very poor return on her investment and completely unacceptable, which is exactly the problem that arose. But it arose not because of any fault on the fund's part. It arose because of the fault in the arrangement as between the municipality and Ms. Mongwaketse. It is not open to the fund in terms of its rules to pay out the full 29.5% times 1.5. That's simply not available under Rule 37.
If, for argument's sake, we were to accept that she was entitled to the 7.5%, can then the municipality have a claim against the fund as an entity with an interest over that complaint?
The municipality wouldn't have a claim against the fund because it did exactly what it was supposed to do, which was contribute from the fund's perspective, its portion, its 22%. The fund doesn't derive any claim as against the fund on that basis. So no, in our submission, the municipality, wouldn't have a claim against the fund, but Ms. Mongwaketse would indeed have a claim against the municipality for the 22% that it paid, that she paid to it, for it to pay over to the fund.
But then if you de-link the two, what purpose would the 22% of the municipality serve in the fund?
Well, it serves a very important purpose, Justice Taletsi, as the papers point out. The 22% is used to fund the various administrative costs of the fund, including the costs of any policies that are taken out to cover the benefits accruing to Ms. Mongwaketse or to any member, and also other costs of administration. So, the 22% and also the payment of the withdrawal benefit. So the 22% is critical from the point of view of the fund.
But then if she's not a member, what purpose does the 22% serve? Because it was not paid because of other members or other employees.
If she's not a member, and that's why we must distinguish between these two propositions. If she's not a member, then she would be entitled to a claim for unjustified enrichment. But what we're saying is that claim is not one which can be adjudicated by the adjudicator. Because if she's not a member, then she wasn't paying contributions under the rules.
Thank you, Justice Malala. Thank you, Mr. McNally.
Thank you.
Thank you, Justice Taletsi.
Mr. McNally, your 40 minutes is up. How much more time do you want?
Justice, I haven't dealt yet with the further arguments that apply to the extent that the jurisdictional arguments don't find favor with the court. I would need probably 25 to 30 minutes just to sketch those arguments. They are dealt with in our heads of argument. I just want to highlight a couple of points.
Just for highlighting, 25 to 30 minutes is not too long. Take it that we have gone through your written submissions thoroughly.
Yes, thank you, Justice Madlanga. I will try to do it in 15 minutes if that pleases the court.
15, please. 15, please.
Thank you, Justice. Justice, so we say that even if you were to find that the adjudicator had jurisdiction, there are nonetheless two main reasons why the determination should be set aside. The first is procedural and the second is on the merits. On the procedural front, the important point, as you will have picked up from the heads of argument, is that the fund had no inkling that this claim was going to be dealt with on the basis that Ms. Mongwaketse was not a member and that her funds would be repaid, or sorry, her contributions would be repaid on the basis of some form of unjustified enrichment. It's quite clear from the fund's response that the fund was dealing with the matter and understood it on the basis that Ms. Mongwaketse was claiming as a member and was claiming her termination benefit as such. And we know that there was additional correspondence which was sent by Ms. Mongwaketse after the complaint was lodged, which is the only item that was sent to the fund. And in that correspondence, Ms. Mongwaketse made it clear that she was claiming on the basis of unjustified enrichment, and she was claiming her money back, as it were. And it's obvious from the determination that the adjudicator ultimately treated the claim as one for restitution on the basis that Ms. Mongwaketse was not a member. And it's our submission that it was incumbent on the adjudicator in those circumstances to advise the fund that she was considering dealing with the matter on the basis that Ms. Mongwaketse was not a member and on the basis of unjustified enrichment, and to give the fund the opportunity to make representations on that basis. We say that there was therefore a fundamental breach of Audi in circumstances where the opportunity to make pertinent representations may have made a material difference to the adjudicator's determination. Then on the merits.
Mr. McNally, if I may, please. Based upon what the fund knew about Ms. Mongwaketse's complaint, it would appear that both the parties understood that the dispute resolved around whether she was a member, and both parties understood that Ms. Mongwaketse was asking for all her contributions to be paid back to her because she was not a member. Now, the complaint of the fund relates to communications that were received June, August, and October, which it seems that those communications add little or nothing to the substance of her complaint. Now, in those circumstances, what prejudice did the fund suffer from not being provided with that communication?
Justice Turon, with respect, this goes back to the point that I raised earlier on, which is that the complaint itself is highly ambiguous. While Ms. Mongwaketse does say that she didn't qualify to be a member, she claims on the basis of a membership payout, the payout of contributions times 1.5 in terms of the rules. And it's quite clear that that is how the fund saw her complaint, and that's hardly surprising given that she had on the 5th of December written a letter to say that even though I don't qualify to be a member, I must be treated as one. So it's quite clear that that is how the fund saw the matter, and that is how the fund responded to the matter. And that must have been clear to the adjudicator. And it is only in the later correspondence that Ms. Mongwaketse refers to a claim as being one for unjustified enrichment, and she claims her money back, not the contributions times 1.5. So with respect, we do say that the fund was not as a fact aware that that was the basis of her claim, that it was on the basis that she was not a member. And as a fact, the fund would have raised the various propositions that it raises now and raised before the Supreme Court of Appeal, which could well have had a fundamental difference to the determination, particularly, for example, the issues relating to enrichment and impoverishment that I'm about to come to.
If we accept that the fund did suffer some prejudice, could this not have been cured by its right of wide appeal before the High Court?
Well, it did raise those very matters before the High Court, and the High Court found, we say wrongly, that the adjudicator had jurisdiction, and those issues of relating to the unjustified enrichment claim have not been given a proper hearing, and it is one of the matters that we impress upon this court, and I'll come to that, as I say, in a moment.
Yes, if I could just digress for a moment before you proceed with your argument, in relation to Rule 15. Rule 15 yes. says that subject to the provisions of these rules, the committee may decide whether any person is qualified to be a member of the fund. And then member is defined in Rule 24.
Yes.
Now, is it not the case, therefore, that Rule 15 only empowers the committee to decide whether someone qualifies as a member in terms of Rule 24?
We would submit that if Rule 24 means what has been suggested by the courts, namely that only employees can be members, then there would be no purpose to 15(1)(a), because it would hardly require a committee to decide whether a person is an employee. They either are or they aren't. And in order to read some sort of meaning into 15(1)(a), what it must mean is that the committee has the power to determine whether a person may qualify to be a member of the fund. And that, as you know, is the basis on which we present our argument. It would seem to be absolutely meaningless if the rules were entirely clear on who could be a member, why the committee would need to decide on who qualifies or not.
Thank you, Mr. McNally.
Justice, I'm running out of time. I'm very conscious of that. I'm going to speed through the balance. On the membership, Justice Theron has raised one of our main points, which is that there is no outright bar against Ms. Mongwaketse being a member. While Rule 24 refers to employees, it doesn't restrict membership to employees. And we say that Rule 15 gives the management committee the discretion. And you know that we make the second argument that Ms. Mongwaketse was not in fact employed for a limited period because there was a mandatory renewal provision in, when I say mandatory, it gave Ms. Mongwaketse the absolute right to request a renewal, and therefore her period of employment was unlimited. And thirdly, we say that, and importantly, the fund accepted Ms. Mongwaketse as a member, and that decision stands unchallenged. And you will recall that a counter application was brought by Ms. Mongwaketse to set aside that decision, which recognizes that that decision, until it's set aside, would stand. So for those three reasons, we submit that the adjudicator was incorrect in her finding that Ms. Mongwaketse could not be and was not and should not be treated as a member. On the unjustified enrichment claim, we emphasize the point that there was no base.
Mr. McNally, I'm sorry, I know you are running out of time, but I have a question on the Odekral argument. If we look at subparagraph 1 in the definition of a complaint, defines the complaint an allegation that, and I quote, a decision of the fund or any person purportedly taken in terms of the rules was in excess of the powers of that fund, or an improper exercise of its powers. Isn't that definition an indication that the legislator intended to vest the adjudicator with the power to set aside the fund's decision on a more informal basis than would ordinarily be required in a review application? In other words, didn't the legislature envisage that a decision of the fund that is ultra vires could be set aside by the adjudicator in certain circumstances? And isn't that what the adjudicator did in this matter?
Yes, we accept that on the face of that clause, it's certainly in the power of the adjudicator to set aside a decision in excess of the powers. Now, we've already dealt with that. And that falls under our jurisdiction argument fundamentally. If we get to the stage where we are looking at the merits, then it's our argument that the decision of the fund to accept Ms. Mongwaketse as a member was not in excess of its powers because of Rule 15. So she was wrong in that regard. If she was correct, then Ms. Mongwaketse was not a member. And that was the end of that decision because she couldn't then go on to determine the common law claim of unjustified enrichment because that falls outside the definition of a complaint. And that leads then to the point that I was making about unjustified enrichment. And that was that there was simply no basis and no argument at all in front of the adjudicator in relation to unjustified enrichment. And there was no basis before her on which she could make that decision. Justice Wallace, of course, supports her insofar as he has little difficulty in concluding that the requirements were satisfied. But we would refer to the judgment of Justice Ponan, particularly in that regard, and suggest that he was correct in saying the following about unjustified enrichment. What he said, and he was quite right with respect in that regard, is that it is recognized to be a complex area of law. He said that it was not clear that Ms. Mongwaketse was impoverished. He said, and this gels with our earlier argument, it was the municipality who made the payments and therefore the municipality who was in the first place impoverished. Ms. Mongwaketse wasn't impoverished at that level because she had a claim against the municipality. She was also not impoverished because, as a fact, the fund covered her for the various benefits, and the fund says that it did. Now, it's been argued by, or it's been found by Justice Wallace, that as a matter of law, Ms. Mongwaketse was not covered, and he relies for that, as you know, on the Connox pension fund matter. Our submission is that the law has developed since Connox pension fund, and it would be a very strange situation now where it could be found that a party who had understood that she was a member in circumstances where the fund too understood that she was a member, where the fund took her contributions and used them to cover her benefits. If the court then held that despite all that, she was in fact not covered. One can imagine if she had a claim, for example, for a disability during the course of her time with the fund, it's unlikely we would submit that a court now would find that she was simply not covered. And on enrichment, again, we say that that's a question of fact. And as a fact, on the papers, the fund used the money paid by Ms. Mongwaketse to purchase the required products and to pay her benefit, her withdrawal benefit. And as a fact, it was not enriched. So we would accord and urge upon you the findings of Justice Ponan at paragraph 77 on page 405 of volume 4, where he says that the adjudicator had no appreciation for the true complexity of the matter, and there was no attempt by her to satisfy herself that any of the requirements had been met. Justices, the only remaining issues are those of prescription, estoppel, and waiver, and we've dealt with those very fully in our heads of argument. The point that we would make in relation to waiver, and this is the last point that I'll make, is simply that Justice Wallace found that there was no right at play because Ms. Mongwaketse was either a member or she wasn't. In our submission, that misses the point. The right that was waived in our submission was the right to raise the issue of her membership as an issue. We say that is analogous with the right, for example, to raise prescription as a defense. A claim has either prescribed or it's not, but the right to raise prescription as a defense can be waived. And we say that waiver was an available defense for the fund to raise in this matter. We've made, in relation I haven't dealt with Cal's submissions. I will deal with those in reply. We have dealt with them by way of comprehensive written submissions. We do, however, simply emphasize that in our submission, neither section 27(1)(c) nor section 34 of the Constitution is implicated. And apart from that, Cal simply raises the same issues as were raised in the court's arquo, which we've already dealt with. And then just on the aspect of leave to appeal, we obviously submit that this appeal raises both constitutional issues and also important issues of general public importance, particularly in relation to the nature and extent of the jurisdiction of the adjudicator. And for that reason, this court will grant leave to appeal. And we would ask that, having granted leave to appeal, the court would uphold the appeal and find in favor of the applicants in this matter. As you please, Justices.
Thank you, Mr. McNally. Mr. Khumalo.
Thank you, Justice Madlanga. You'd be surprised that my device has failed me, so I'm now using my Leonard Jr.'s device. It was working fine when we were talking to you this morning. Suddenly it froze.
You
Justices,
you are here.
Thank you, Justice. I hope you can hear me because I haven't tested this device before.
Loud and clear, loud and clear.
Justices, I intend to use my 10 minutes very usefully and just address some of the issues that the justices have addressed with my learned friend. I will come back to our main submissions later. We would invite this court to have regard to paragraphs 20 to 39 of Justice Van der Linde's judgment, because there he sets out in detail what the complaint was and the various interactions between the complainant and the fund over a period of 2 years. Because before a complaint was lodged, this person went to the fund and raised issues with the fund. And the court will clearly see that a year before the complaint was lodged, complainant asked for a refund of her contributions. So the applicants knew that that was her complaint. And in paragraph 40 of Justice Van der Linde's judgment, he says something very important. He says these facts were not disputed by the applicants, meaning those facts that he sets out from paragraph 20 to paragraph 39 were common cause. Now, if the court has regard to those facts, it disposes of the waiver argument. It disposes of the prescription argument. It even disposes of the estoppel argument, because those common cause facts cannot give rise to a waiver defense or an estoppel defense or a prescription defense for that matter. The applicants cannot come to the Constitutional Court with alternative facts when those facts were common cause before the High Court. I just wanted to make that clear. And Justice Theron, you raised an important issue because the applicants seem to be oblivious to the fact that Section 30P proceedings are neither an appeal nor a review. They are de novo proceedings where the High Court reconsiders the merits of the complaint, not the determination of the adjudicator, but the merits of the complaint. So if they had any defenses to the complaint, that's the place where they were supposed to raise those defenses. They cannot, in an appeal to the Constitutional Court or the SCA, say, oh, by the way, I had defenses, but I did not raise them. If I was in alternative proceedings, then I would have raised them. As Justice Wallace correctly pointed out in the SCA, they did not raise these defenses. He was simply indulging them by addressing them. And he gave them a short shrift, and rightly so. Because the opportunity to raise those defenses, assuming there was anything procedurally incorrect in the adjudicator's office, was in a 30P complaint. And as Justice Wallace correctly pointed out, anything you could have raised under PAJA, you could have also raised against 30P. So it does not really make a difference. That's why the courts did not entertain the PAJA issue, because they dealt with the application as a Section 30P application. And it was dismissed on that basis. As far as the Constitution is concerned, I'm going to move very quickly. Section 39(2) enjoins this court, when interpreting Chapter 5A of the Pension Funds Act, to promote the spirit and objects of the Bill of Rights. This court knows that litigation is expensive. This court knows that if you are a member in the Eastern Cape and you want to sue a pension fund in Johannesburg, you would have to sue it in Johannesburg. You cannot sue it in the Eastern Cape. The Office of the Adjudicator assists because wherever you are in South Africa, all you need to do is write down on a piece of paper what your complaint is and fax it to the adjudicator, and the adjudicator will hear it, because there are no territorial jurisdiction issues. Any complaint throughout the country, the adjudicator can hear it. That's why we are inviting this court, when it interprets Chapter 4 and those provisions in Section 1 of the Pension Funds Act that deals with complaints and complainants, you interpret them in such a way that you don't limit right of access to that tribunal. Justice Rogers, you asked a question, examples in paragraph D of the definition of complainant. It's not a surprise that the applicants could not come up with an example. And they're a pension fund that has existed so many years. You would think that there would be a readily available example, but there isn't. Because why would anybody be a complainant in somebody else's complaint? It doesn't make sense. If you have a complaint, you lodge your own complaint. You cannot come in and say, I'm coming in because somebody has lodged a complaint and I'm a complainant in somebody else's complaint. It simply does not make sense. Now, let me give you then live examples. I was involved recently in a matter where the father of a minor child lodged a complaint on behalf of that minor child because the child was obviously too young, cannot lodge that complaint himself or herself. So under paragraph D, the father can simply come in and say, my child was badly treated when the death benefits of her mother were distributed between family members. I'm lodging a complaint on behalf of my minor child. Paragraph 4 would cover such a person. Another example, if a new employee joins the company, and in terms of the rules, the employer must enroll new employees with the pension fund. At that stage, that employee is not a member of the pension fund. But in terms of the rules, the employer must enroll that employee in order for the employee to become a member. Paragraph 4 covers that employee. He's not yet a member, but because the definition of complaint says in paragraph D, a complaint that the employer who participates in the fund has not fulfilled its duties in terms of the rules of the fund, you are then covered under that definition. So the legislature was aware of situations like this. I can also refer the court to section 37C2 of the Pension Funds Act, where that section makes provision for payment of benefits to people like guardians, to people like curator ad litems, to people like trustees. Now, in terms of the Act, payment can be made to those people. Now, those people are not covered under either paragraph A to C of definition of complainant. But because all that relates to administration of a pension fund, they can fall under paragraph D and lodge a complaint with the adjudicator, and the adjudicator can resolve that. So there is method to the madness. But the argument the applicants wish to advance is so absurd that it will leave so many people out, and they will simply have to go to court. And if they cannot afford lawyers, that's the end of it. If they were entitled to benefits in a pension fund, they lose out. And this is where now the Section 27 argument comes in. Parliament could never have contemplated that. So I hope I have addressed definition of complainant. And it's quite clear then when you read complaint, because our learned friend also made an argument that the adjudicator is not meant to deal with common law claims. But the adjudicator deals with common law claims all the time, and claims that don't necessarily relate to the rules. Justices, I will give you a simple example. In pension funds, members are allowed to switch between investment portfolios, or sometimes they are allowed to choose where their fund values must be invested. Now, they are given an election, they complete a form, they sign that form. If their election is not given effect to, they either have a contractual claim or a delictual claim. That's a common law claim that the adjudicator regularly deals with. So the suggestion that the adjudicator is not meant to deal with complex common law claims is simply without merit. If one has a regard to definition of complaint, paragraph C, it says that a dispute of fact or law has arisen in relation to a fund between the fund or any person and the complainant. So the adjudicator is meant to deal with disputes of law and fact. That's why the Act requires that the adjudicator must be somebody who has been in practice for more than 10 years. But in addition to that, must have knowledge of pension fund issues so that they can be able to deal with all these complex matters. So the suggestion that the adjudicator cannot deal with complex common law claims is with respect without merit. 13A is completely against the applicants. We invite this court, Section 13 of the Pension Funds Act is completely against the applicants. And we invite this court to read Section 13 together with the Abrahamse versus Connox judgment. Our learned friend said, Connox is old. But that is only testimony to how good a judgment is. It cannot be a criticism to say, because it's a 58-year-old judgment is bad law. With respect, that cannot be criticism. It is good law because it has stood the test of time. And we've referred the court in our heads to the APSA against Sakau judgment, his 2012 judgment of the SCA, where Connox was followed. We've referred to 2018 judgments where the court has consistently followed Connox. We've referred to the famous Brian Molefe judgment, 2018 TPD, Gauteng Division now, where Connox was followed. So it is good law despite the number of years that it has been there. So just this is our submissions in a nutshell. She qualified as a complainant because she paid money to the fund. She paid money to the fund because she was saving for her retirement. It transpired that she was not eligible for membership. And the only remedy available is a refund. It's not a defense to say we have used the money.
Mr.
Because,
sorry to stop you mid-sentence. The 10 minutes is up, but continue.
Justice Madlanga, with your leave, I'm just going to finalize this last point and say it is not a defense to say we have used the money and therefore there's no enrichment, because even the use of the money was contrary to the rules, meaning it was ultra-virus. So for the same reason that she's entitled to receive her side of the contributions, she's also entitled to receive the employer side of the contributions. Because the law is the same. You can't split the law as far as one section of contributions and the other. If it was ultra-virus to receive contributions and you are supposed to refund them to her, then you refund all of them. You cannot say, I cannot refund some of the contributions because I have used those. I remember running the same argument in the Guaneri matter referred to in the SCA judgment. And the justices there made it clear that that's not a defense. If you've used the money to do whatever, then you've used the fund's money. But you must still pay back what you are supposed to pay back to the people who are entitled to the money. So Justice
Khumalo, just two questions. Can I ask you this? On the definition of complainant, and particularly your interpretation of item D of that definition.
Yes.
On that interpretation, could one just delete A to C of the definition and say that a complainant is any person who has an interest in a complaint? This is an argument that is raised against you. They say, well, obviously a member or a group of persons, a board, one must take it for granted that that includes people with an interest in a complaint. So on your interpretation of D, does D effectively do all the work and A to C become irrelevant?
Justice Rogers, D is a catch-all, so it covers all those people who are not covered under A to C. And Justice Rogers, you would know this, the Pension Funds Act is never an elegant piece of legislation. It was never meant to be. So what has happened here is Parliament saw fit to define those people who have a direct relationship with the pension fund in accordance with the type of relationship they have. That's why you have member, you have former member, you have employer, you have a spouse for different reasons. Then if you are not any of those, then there's a catch-all. provision and it captures you. That's the purpose of paragraph D.
No, I can understand a catch-all category, but then it appears to me that that catch-all category also catches A, B, and C, rendering them perhaps practically irrelevant.
I would submit not necessarily, because I can think of a scenario where somebody says, I'm a member in terms of 1A. In the event that you find that I'm not a member under 1A, then I qualify under D.
Yes, but either way, that person would be saying, I have an interest in the complaint. You wouldn't need A.
Well, it depends which route you choose to follow, Justice Rogers, because you could come in directly under paragraph D.
All right, the other question which relates to the definition of complaint, once one accepts your, if I can call it the wide interpretation of D, of the definition of complainant, then if there is to be any limit on what the adjudicator can do, it has to come in via the definition of complaint. Because on your argument, anybody who has an interest in a complaint gets in, whether or not they're a member or a letter. Now, do you say there is any limit? And perhaps just to give examples, a dispute between a pension fund and one of its investment managers, a dispute between a pension fund and its administrator, a dispute between a pension fund and its IT service provider or its landlord. All of those matters could at least be said to relate either to the administration of the fund, because it's concerning the administration of its affairs, or in the case of the investment manager, the investment of its funds. Do you say that all of those types of disputes could go via the adjudicator?
No, Justice Rogers. And we made an example in the heads of somebody who says, this pension fund has the same name that I have. I'm lodging a complaint because I want them to change their name. They cannot. And it's the same with a building dispute. A building dispute would not be covered under any of the provisions because, as we said in our heads, you must interpret administration to mean the administration activities set out in the chapter of the Act that deals with administration. The term administration is not defined, so you have to go to the body of the Act and say, what did Parliament have in mind when it was talking about administration? It's not talking about general administration. It is talking about administration of the business of the pension fund. And that you find in sections 12 to 13A of the Pension Funds Act.
So you seek to limit or to impose a sensible limit on what the adjudicator can do by saying the phrase administration of a fund, for example, includes excludes the broad administration of its affairs in the sense of its contractual disputes with service providers. You would say that although a landlord or an IT service provider or an investment manager might have an interest in a complaint, that wouldn't concern the administration of the fund if they, for example, were alleging a breach of an IT service contract or an administration contract. You say that wouldn't fall within the administration of the fund.
Justice Rogers, we say it would not. So if you have regard to Chapter 3 of the Pension Funds Act, it starts from section 7. And it continues, I believe, to section 50. The heading there says manner of administration and powers of registered pension funds. And if you go to section 13, capital letter B of the Pension Funds Act, it talks specifically about who may administer a pension fund. And it says administration involves receipt of contribution, investment of benefits, and payments of benefits to members and beneficiaries. That's the administration contemplated in the definition.
Now it's that limitation. If you recall, Judge Unterholter in that other matter in his interim judgment, which Judge Buhler then followed,
yes,
didn't base the view on the definition of complainant, but on the concept of what constituted the administration of a fund. And Now, on what you have submitted as to how one would keep out a wide range of commercial disputes from the jurisdiction of the pension fund adjudicator, I think your opponent in this case raises that point to say, well, if a person is a member, then clearly the receipt and administration of their funds falls within the concept of a complaint. But if the true position is that the person is not a member, in legal terms, Ms. Mongwaketse is a stranger to the fund. She is just a stranger who has happened to pay them some money, which she shouldn't have paid them. Now, why is that more administration of the fund than your contractual dispute between the fund and the IT service provider or the administrator of the fund?
Justice Rogers, because it relates specifically to the administration functions defined in 13B of the Pension Funds Act. And I'll give you another example, Justice Rogers. Say, for example, I go to the regulator, the FSCA, and I complain to the regulator that the building owner is administering the pension fund in violation of Section 13B of the Pension Funds Act, or in violation of the entire statute. The regulator would go to Section 13B, subsection 1, and say, no, when the Act talks about administration, this is what it is talking about. It is talking about the receipt of contributions, disposition of benefits, and the investment of the assets of the pension fund.
Now, in this case, was the money paid by Ms. Mongwaketse, did it involve the receipt of contributions within the meaning of Section 13B?
It did, Justice Rogers, because that's all it could be. It wasn't payment of a debt. It wasn't payment of anything. It was monies deducted from her salary in terms of the contract of employment for the purposes of contributing those monies to a pension fund.
Well,
as she said so herself, I was making provision for my retirement.
No, we know what she intended, and we know in what state of mind the pension fund received the money. Yes. But something either has the character of a contribution or it doesn't. And your opponent says, well, if she's not a member, it doesn't have the character of contributions. It's like any condictio in debiti. I have paid money thinking it had a certain character, but I was mistaken. It was just a payment of a sum of money which wasn't owed. And theoretically, anybody, not only a person who thought they were a member could do that. A contracting party with the pension fund could overpay in some way. At what point do you say it's enough that it was a purported contribution?
We say that's enough. And Justice Rogers, we would submit that those are different issues, because whether she qualified as a member or not is a different issue. And it depends on what the rules say. But what she was paying to the fund is governed by a different rule, which says you must pay to the fund X in lieu of contributions. When a different service provider pays money to a pension fund, we know that it's not for that purpose. And it cannot be intended for that purpose. So it must definitely be a payment made in error. But here, all parties were in agreement that what is being deducted from the salary and being paid across to the pension fund is a contribution. It so happens that in terms of the rules, that contribution was not due, but it does not change the nature of what it is that was paid to the pension fund.
Mr. Kumalo, can I just follow up on that if my brother Rogers has finished?
Yes, I have.
Thank you. You accept then that this must be a claim for unjustified enrichment, probably the condictio in debiti.
We made two submissions in our heads, Justice Majid. We said it could either be a condictio or a normal contractual restitution claim, where you say the contract has failed, I performed, you cannot perform, please refund my money.
Yes. Yes, no, but on either of those, what bothers me somewhat is I think it's common cause on the papers that this determination was made by the adjudicator at a stage and in circumstances where the fund was unaware of the communications by Ms. Mongwaketse, where she raises this claim either based on the condictio or on the contract restitutionary claim, as you put it. And those letters were sent in June 2017, August 2017, and October 2017. Do you accept that the fund was never appraised of those communications on the papers?
Justice Majid, on the papers, I would accept that those communications that came after the response, the fund was not appraised of those. That's why when I started my submissions, I referred the court to Justice Van der Linde's judgment. And if the court goes to paragraph 29 of Justice Van der Linde's judgment, it is quite clear that as far back as the 25th of September 2015, a request was made to the fund to refund the contributions. And there was a series of meetings where at one point it looked like the fund was going to do so, then it reneged, and there was this back and forth. It was only when she got tired of the lack of progress in that regard that she went to the adjudicator. But all of this preceded the complaint to the adjudicator. And it was accepted by Justice Van der Linde as common cause that as far back as September 2015, they knew that what she wanted was a refund of her contributions.
So you say what you are saying is outside of the complaint to the adjudicator, the fund was very well aware that what Ms. Mongwaketse seeks is a refund of her monies, of all her contributions.
Absolutely, Justice Majid, because the Pension Funds Act in 30A1 says before you go to the adjudicator, you must go to the fund.
Yes.
And even that which you do with the fund qualifies as a complaint.
Yes.
Only if the fund does not resolve it to your satisfaction, then you go to the adjudicator.
Yes.
And these facts were accepted as common cause by Justice Van der Linde that as far back as 2015, the fund knew that that's what she wanted. So they cannot claim prejudice by saying, well, when the reply came, the position was suddenly different. And that's the answer I gave earlier in relation to what Justice Theron posed to our learned friends. But if you were aggrieved or you were unhappy with the procedure, you get the second bite where you have a hearing de novo and you can raise these things. But if you accept these facts as common cause in the High Court, you cannot later in the Constitutional Court come up with either alternative facts or say to the Constitutional Court, if I had a chance, I would have raised these defenses. You had a chance and it was the 30P application.
Now that brings me neatly to the next question that I have is the section 30P procedure. Do you support the SCA majority judgment which says that PAJA is not applicable exactly because of the section 30P procedure, which is a completely new de novo hearing before a court?
Yes, Justice Majid. And I support the reasoning also because under PAJA you are limited.
Yes.
Because you are reviewing the adjudicator's decision. Whereas under 30P, it's a de novo hearing of the complaint. You're not reviewing the adjudicator's determination. The court is actually looking at the complainant's complaint afresh, and you can bring in whatever evidence you want subject to the limitation in 30P3, and the court reconsiders. So it exercises original jurisdiction over the complaint. So you get a better deal under 30P than you would under PAJA. And by the way, there was a further point. It won't apply to this case, Justice Majid, but just to complete the answer, since 2017,
the equity
internal remedy is now the tribunal, the FSCA tribunal.
Yes.
So that's the internal remedy before you invoke PAJA. But because this case was decided prior to that, those provisions would not apply. So I support the SCA's judgment as far as it says that PAJA would not be applicable because the Act gives you something better than PAJA.
Now, the fund argues that this ouster of review must be pertinent because it it is an ouster which the Constitution normally would not permit. Do you say that that ouster is pertinently specified in the Section 30P procedure? The ouster of any possible review proceedings on behalf of the fund?
I would submit that that is the purpose of 30P. Because why would you have those parallel processes, Justice Majid?
Yes, thank you, Mr. Kumalo.
Parliament wanted to make sure that if you are aggrieved either by procedure or substance before the adjudicators tribunal, have a fresh hearing on the same issues before a court.
Thank you.
And just to conclude, Justice Majid, you will recall that the court, the SCA, said it doesn't matter anyway because the same grounds of review they were raising were the same issues that they raised in the 30P application. It was the procedure, it was the jurisdiction, and it was the rationality. All the issues that could be dealt with under 30P and were in fact dealt with under 30P. Thank you, Justice Majid.
Continue, Mr. Kumalo.
Justice Madlanga, I have made my
unless you are done.
I have made my submissions. I just want to have a look at my notes to see if there's anything that is remaining. Yes, Mayor versus ISCO deals with 30P and the fact that is a hearing de novo. And the one last point, which I thought was useful, our learned friend in his argument said this complaint specifically has nothing to do with the interpretation of the rules of a pension fund. And we submit that it has everything to do with the interpretation of the rules of a pension fund, because it is in the rules where you find eligibility criteria for membership. So the adjudicator would have had to go to the rules to determine whether this person qualified as a member or not. And in fact, that was the ratio. It was the rules. The adjudicator went to the rules and said, in terms of the rules, you do not qualify for membership. And the one last point, sorry, there are two because I must deal with Rule 15. The point our learned friend made that Ms. Mongwaketse was not a temporary employee. Our learned friends, with respect, have overlooked, I think it's paragraph 2 of the SCA's judgment, where the SCA made it clear that the second provision in the contract that provides for renewal is unlawful. And because that second part is unlawful, her term was fixed for 5 years. After 5 years, the municipality would have had to advertise this position. They could not simply renew her contract. So the SCA dealt with that. Maybe our learned friends may have overlooked it. And as far as Rule 15 of the rules of this fund, it says nothing of the sort. It doesn't give the trustees discretion to admit somebody who does not qualify for membership. It simply says, subject to the provisions of the rules, the committee may decide whether any person is qualified to be a member of the fund. In other words, if there's a dispute, the committee can decide that. But it does not mean that if you don't qualify in terms of the rules, the committee can admit you, contrary to what the rules say, and contrary to what Section 13 of the Pension Funds Act says. Because as we said in our heads, Section 13 must be read with the regulations that deals with rules and what the rules must provide for. They must also be read with the Income Tax Act, which is quite strict as far as what the rules of pension funds must provide, including specifically eligibility criteria. So justices, we submit that if you follow Section 13 and you follow Abraham said, there can only be one conclusion. The appeal would have to be dismissed, because if everything the fund has done is ultra vires the rules, then they have been enriched. And they cannot make argument and say, oh, but we provided you this benefit, we provided you that benefit. As a matter of fact, they did not. And as a matter of law, they could not. If they used any money, it was the fund's money. It was not the contributions that came from Ms. Mongwaketse. And as Justice Lalesi correctly pointed out, because she was on a cost to company arrangement, her salary had already accrued to her when the contributions were made. So it was her money because it was accrued income. And all the contributions were deducted from income that had already accrued to her and were incorrectly, as we now know, paid to the fund. So with respect, she's the only person who can claim those contributions back because that money had already accrued to her. It no longer belonged to the employer. Justice Madlanga, those are our submissions, and we thank the court for allowing us to make submissions. And we have provided the court material which we thought would be useful to assist the court to understand where the Pension Funds Act comes from, what is the purpose of Chapter 5A, and also why this court should interpret those provisions in such a way that nobody is left out, because the consequences, as you can imagine, would be devastating. Anybody who's left out will not be able to rely on this procedure to go to the adjudicator, but more importantly, because there's a bigger right, as we said, approaching the cause and approaching the adjudicator, it's a procedural step. But you go there because you want to vindicate a much bigger right. Your right to make a living through the monies that have been properly earned from your employer, and you save them in the hope that should you retire or you be dismissed from employment, you would make use of those monies. So I cannot pitch it higher than that as far as Section 27 and 34 are concerned, but those are our submissions, and we thank you for the audience.
Thanks to you, Mr. Kumalo. Mr. McNally?
Thank you, Justice Madlanga. May I start my reply, and it will be brief, by referring to the question that Justice Rogers put to me and to which I could not come up with a ready answer. And that was, what class of people might come under sub D of the definition of complainant? The answer to that with respect was assisted by my learned friend's submission, where he made the point that A to C is Parliament's attempt to define parties with a direct relationship with a fund. And we would accept that on the face of it, it appears that that is so. But we would say that what that indicates is that sub D refers to parties with an indirect relationship to a fund. And the only examples I was able to come up with, and I hope that they are helpful, is firstly, for example, the beneficiary of the estate of a late former member who might have a claim against, or an interest in a claim against the fund. Or another example might be a partner who is in partnership with a member. Those are the kind of people we suggest would have an indirect relationship to the fund, and it is to them that subsection D is directed. And that then leads into the next point, which is the point again made by Justice Rogers, which was a point which we made in our argument, namely that the wide definition that's suggested for sub D would really do away with any need for subs A and C. And in our submission, it is correct. And our learned friend had no real answer to that. He said it just depends which section you come under, but that's not an answer. The point is that anyone could come under D and there would be no need for A to C. Now, on our interpretation, A to C retain their meaning. Now, my learned friend says, and we say that analysis of the definition of complainant and complaint is necessary to create the correct limits to the jurisdiction of the administrator. The learned friend suggests that you don't need that to restrict the jurisdiction, because what you have is, and his example was, a limit on what would constitute the administration of the fund. But when questioned about that, he first suggested that administration is something that relates to the administration of the business of a pension fund. But of course, if that were so, it wouldn't exclude the kind of examples that were put to him, like a dispute between the pension fund and an investment manager or its landlord. So he then suggested that no, the definition of administration should be further curtailed, as it were, by reference to such sections of the Pension Funds Act as 13A and 13B. He relied particularly on 13B, which talks about administration of the receipt of contributions. And then it was put to him, yes, but what if the payments are not contributions? And my learned friend suggested that it would be enough if they purport to be contributions. But with respect, that's not in keeping with the wording of 13B or indeed 13A, which also refers to contributions. Both sections, 13B1, for example, talks about contributions or the disposition of benefits, quote, provided for in the rules of the fund. And in 13A, sub 1A, any contribution which in terms of the rules of the fund, and likewise sub B. So for a contribution to fall within the definition of contribution, and therefore to fall within the definition of the administration of of a fund, it must, we say, be a contribution paid in terms of the rules, not one which purports to be paid in terms of the rules.
Mr. McNally, I'm sorry to interrupt you. The deduction could only have been made from her salary if it was a contribution.
No, with respect, not, Justice Theron. That's exactly the point. If it was a contribution, then it wouldn't be subject to a claim for unjustified enrichment. The reason it's a claim for unjustified enrichment is that it was paid not as a contribution, but it was paid in debiti or sine causa. Contribution gives it a causa. And if it was paid as a contribution, then our arguments to the effect that, in fact, Ms. Mongwaketse should be seen and treated as a member have a certain force. And if she's seen and treated as a member, then she was, in fact, paid out what was due to her. And her further claim, which relates to the 22%, is a claim properly made against the municipality and not against the fund. Her claim against the fund as a member is her claim for 7.5% times 1.5.
Let me rephrase that. The fund would not have been entitled to deduct those monies from her salary unless it considered it to be a contribution.
Yes,
and
it did.
She would not have allowed that deduction unless she considered it to be a contribution.
Yes, Justice Theron, I understand that, but that's the point that this case raises, and it's exactly that point. It is correct that the trust understood that it was deducting contributions. It also happens to be correct, and this is important for a later argument, that Ms. Mongwaketse understood that she was paying contributions, and that you know from her letter of 5 December, which is referred to in the papers at page 240, paragraph 21, and again it's accepted at 241, paragraph 25, that the fund also considered her to be a member. So if she was a member, then they were contributions. But if she was not a member, then they were not contributions. And that is the situation we're dealing with when we're dealing with jurisdiction. It's the situation where she was not a member and therefore not a complainant. And in those circumstances, her claim is not for repayment of contributions, but for repayment of amounts paid sine causa. It's suggested, I think the debate was between, I think, Justice Majid and my learned friend in relation to the awareness of the fund of the nature of the complaint. And it was suggested that the fund was always aware that Ms. Mongwaketse was claiming as a non-member for amounts paid sine causa. That is simply not borne out with respect by the papers. And again, I would refer to the letter of 5 December, where, and I just read it because it's in important terms. It's at page 240, paragraph 21. And what she says in that letter, and it's quoted at paragraph 21, she says she has been a contributing member of the fund, and as such, she regards herself as a member of the fund, irrespective of the fact that she's appointed on a 5-year fixed-term contract. So she insisted that she was in fact a member of the fund, and the fund itself accepted that position and accepted her as being a member of the fund. Well, that goes to our argument on the merits. But if that argument is wrong, then we fall back to our position that she was a non-member and therefore not a complainant. Now, it doesn't matter whether she approached the adjudicator as a non-member or whether she approached the adjudicator claiming to be a member. In the first case, it wasn't a complaint because she wasn't a complainant. In the second case, she was a complainant, and it was a complaint up until the moment that it was determined that she was not a member. Once that was determined, then jurisdiction, the adjudicator no longer had jurisdiction because the complaint did not fall within the 3 jurisdictional threshold requirements in the preamble to the definition of complaint. My learned friend referred to the point that was made by Justice Wallace about the provision for the extension of the contract of Ms. Mongwaketse. And indeed, that was a point raised by Justice Wallace, and you will find it in volume 4 right at the beginning of his judgment at page 369, where he doesn't identify the provision, but he says a provision in her contract directed at circumventing this requirement, that's the requirement that her post be re-advertised, can be ignored for present purposes, as this court has held such provisions to be ineffective. And he relies on the Mawonga versus Walter Sisulu municipality case. With respect, that is...
The 10 minutes is up, Mr. McNally. How much more time do you want?
Just 1 minute, Justice, just 1 minute. The point is that that case deals with a different situation and one which is not applicable to Ms. Mongwaketse. It deals with section 54 of the Local Government Municipal Systems Act and relates to the contract of a municipal manager, which in terms of statute is limited to a period of 5 years. That does not apply to the contract of Ms. Mongwaketse, who was the chief audit executive. I think that her contract is governed by section 57 of the same act. And then finally, I did say 1 minute. I just want to give the court a reference. I think it was Justice Tron who raised with me the Odekral argument, and we simply refer this court to the decision in Aquila Steel, that's Aquila Steel, at 2019, volume 3 of the South African Law Reports at page 621. It's a decision of this court where at paragraph 94, the court stated that the court's role in determining legality is preeminent and exclusive. And so that's just a response to the question that was raised in relation to the Odecroll point. And then the final point that I make is my learned friend talks about access, section 34 access, on the basis that the mechanism provided for under the Pension Funds Act is simpler, essentially, than requiring a stranger to the fund, such as Ms. Mongwaketse, to go to court. But of course, our response to that is jurisdiction is not determined by how easy it might be to use a mechanism. It's determined by a proper interpretation of the relevant sections. And the fact that it's a little easier, or maybe, we don't concede that, as you know, in the heads of argument, the fact that it may be a little easier is no basis for extending jurisdiction. Sorry, Justice Madlanga, those are my further submissions.
Thank you, Mr. McNally. Thank you very much to both counsel for the assistance you've given to the court. Judgment will be reserved. Court adjourned.
Thank you, Justices.
Today's proceedings have concluded. The host will now terminate the meeting.